Hi, this is Kurt Harris with the Men's Family Court column. Today I want to talk to you about depositions. Now, I've spoken on other occasions about discovery, and the deposition is a phase of discovery where you have the ability to set the deposition of the other party and to have a sit down with them, and your attorney can ask them questions and they need to answer those questions under oath. A deposition is an exploratory question and answer period where you are able to glean and obtain a great deal of information directly from the adverse party in your litigation. During a divorce proceeding, you have the ability to depose the other party if you so choose. Many times and many parties do that in that process of discovery, and you are able to obtain certain information that you couldn't get otherwise. It also enables you to get certain information to prepare yourself for a forthcoming trial. Depositions can be very useful and be very helpful in obtaining information and in getting a record, a sworn statement of the other party. At the close of the deposition, the other party has the opportunity to read and verify, and then you will get a transcript that is printed up. That transcript essentially encapsulates the other party's testimony on the record, and you're able to cross-examine them about their prior statements in the future at the time of trial, or you're able to use that for other reasons on motions before the court. Depositions can be incredibly useful and incredibly helpful. On the downside, depositions can be very expensive. It's very expensive to have your attorney prepare for a deposition. It's very expensive to sit down and to have that time dedicated to the deposition process. And finally, transcripts from a licensed court reporter can be very expensive. And so you need to be prepared that you may be charged $800 to $2,000 for a deposition transcript. That may be a lot of money that you might not be able to afford, and so it's something to consider. A second downside that I find with depositions is that often it prepares the other side for trial. It prepares the adverse witness for what's coming, and those same questions that you may be asking at trial are presented at the time of the deposition, and that enables someone to better prepare for trial, and sometimes you actually can help the other party depending upon the questions you ask and the demeanor in which you attack them at a deposition. I've seen many attorneys go on the attack in a deposition. I do not believe that to be fruitful, and I think that only prepares my clients better for what's coming. I don't believe that depositions should be adversarial, but more information gathering. So the deposition is a very vital part of the discovery process, but one which I would caution you to use limitedly and for a very limited purpose or basis. Otherwise, you might be best not to exercise the right to take the deposition of the adverse party. Again, this is Kurt Harris with the Men's Family Court column. I look forward to speaking to you on other topics in the very near future. Thank you.